This morning we're going to talk about when size does matter. I haven't lost the plot, it's okay. We're talking terms of business agreements, contract for securing your investor, that kind of thing. And working through the National Association and assessing a lot of individuals and company documents as we do to approve them, we see all sorts of different contracts coming through the doors and being put in front of me. And so I wanted to talk to you this morning about the fact that the contract that you use to secure your investor is probably the most important document within the pack that you should have. Yes, others are equally, they're incredibly important, but the contract is the one thing that holds your investor to actually legally paying you. And for those of you that have been given a one page, forget it. It won't work. It won't hold anything or anyone. And the other issue that we're coming across as well is when complaints are made about sourcing agents through to the redress scheme and through the National Association, we're working closely with them, and they're giving us the background to these complaints, not necessarily the company names, but the background to the complaint, what the complaint was, how they assessed it, and the award that was made at the end with the decision. And what we're finding a lot is that the contracts are just not good enough. In fact, quite often incredibly poor. An NDA, just bin it. It's not going anywhere. It's not doing anything. It doesn't protect you. It doesn't protect the buyer. What you need is a full-blown working agreement. Now, you don't have to come and buy all of our contract pack. You can go to a document called Simply-Docs, and for £40, they have a business-to-business, or we use the business-to-consumer contract that's sitting under the business heading. And there's lots of other documents under there that you can download for the £40 in a year. Now, our terms of business agreement over the years that we've had it, and I wrote it myself and then have it checked on a relatively regular basis by our commercial contract solicitors, is 16 pages long now. And so you can see why one page NDA versus terms of business agreement, formal contract, 16 pages, just isn't going to hack it. Why is that? Because in law, there are a lot of clauses that legally should be in agreements. And yes, it's true that if you write an agreement and someone reads it and signs it, technically it's an agreement, but will it hold water in a complaint? No. Because there are certain things that the redress schemes certainly are looking for if a complaint is made in any way, shape or form about taking deposits, holding deposits if they're refundable, how much is taken, etc. Things that you really need to sit down and think about before you start operating your business. Certain clauses in there that should be highlighted and brought to the attention of your potential client. Let's face it, how many of us honestly sit down in front of paperwork that's legal paperwork and read through every clause, every word, every paragraph, every statement for the whole document? How many of us honestly scan through? And investors are probably no different than that. In fact, quite often the sourcing agents that write the documents or edit the documents scan through them but don't really understand what's in it. It's an agreement, your buyer signs it, they're secured to you. They're not particularly interested about what's in. But if you don't understand what's in the agreement, how can you know if it's good enough or not? So you're looking at various clauses that are legal requirements to make it a legal document. You're looking at various clauses which describe in detail what it is that you do, what it is that you're promising, what payments you want to take, when you're going to take them, What's the status of the payments? How do they get a refund? Under what circumstances can they get a refund? And if those clauses aren't in there, or if they're not clear, and a complaint is made against you through the Ombudsman, the redress schemes, quite likely you will lose. And from what we've seen, the awards are sitting at around about what I would say is a standard sourcing fee. So around about the 2 to 4, 5k mark. So this is quite serious for you as sourcing agents. So does size really matter? Yes, it does in this case. But more than the size and the volume of the document, the contents of the document, it has to be reasonably easy to read. And I do know that some of the legalese in there, I've wanted to take it out for years, and our commercial contract solicitors say, no, Tina, you can't do that. Legally, that statement has to be in. But I try to make ours as easily readable as possible. And any sections that I think that are really pertinent to a potential client, we state that we're bringing attention to this clause, that you should pay attention to it, and we make it bold. Because the other thing that the redress schemes look at is, are these pertinent clauses clear? If you're going to say to or expect a client to sign and say, I'm going to pay you £1,000 a month for the next 24 months, and you can't, even if you cancel, you still got to pay me, and that's in tiny, tiny small print, and it's not brought to their attention, if a complaint's made, you might well get an award made against you. So anything that is really pertinent, sit down and think about what you would want to know about. If you were signing this agreement with a sourcing agent, what are the key aspects, what are the key points that you would like to know about? And then those should be in your agreements. But there is a really good quality baseline terms of business agreement contract on Simply-Docs under the business section. It's £40 for the year. We use business to consumer. Why? Because business to business, you don't have to have the 14-day cancellation notice on under the business protection regulations, but under consumer protection regulations you do. And I know that a lot of investors invest through a business structure, but trust me when I say it is much safer for you if you treat everyone as if they are a consumer. You offer them the 14-day cancellation notice, but there is a form at the bottom of the document that potential client can sign to waiver that 14-day cancellation. So that's a little bit about why size matters and about contracts this morning. I hope it was useful to you.